the Virginia Circuit Court of Appeals gets ready for the traveling circus that's the Depp versus Heard show. Let's see how that probably looks up there now.
To read it is out of sheer morbid curiosity. I'm allowing this freak show to continue.
Let's take a look at a couple of questions that had, it seemed to me, remain hanging from comments that I've seen on responses to things about the appeal bond, and all that. So let's talk about perjury, lies, and the First Amendment. Perjury is a crime, obviously, and like any other thing in the law, if you're going to prosecute somebody for it or sue somebody for it, there's certain elements that have to be met. So what is perjury? It's a state issue, so it can be different according to each state, but the case we're talking about is in Virginia. So let's look at the Virginia statute, 18.2.434. A person to whom an oath is lawfully administered willfully swears falsely on any material matter or thing. Well, that seems easy to understand, and in this case, it kind of actually is. If you give sworn conflicting testimony with intent to testify falsely, that's perjury. You also can't induce someone else to commit perjury. Straightforward. So a lawyer looking at this is going to say, well, it has to be a material thing. It can't be about the color of somebody's shirt if that doesn't matter to the case. Obviously, it has to be something that the prosecution can show is false. This person said that, and the prosecution will be able to show beyond a reasonable doubt that that wasn't true. But the other catch is willfully, or with intent. Willfully. That's an important word in the law. Let's look at the famous Constanza defense.
Jerry, just remember, it's not a lie if you believe it.
Exactly. Is it a lie? Was it willful? That depends on the intent of the person making the utterance. Now, it is true that that can be proven, even if the person doesn't confess it, by the facts and circumstances surrounding that. But generally, perjury charges, criminal charges in the United States are very rare, especially in civil cases. Say, for instance, in this case, if you think that Amber Heard committed perjury, you think she intentionally lied on the stand, well, why isn't she being charged with that? Well, who cares? From the law enforcement standpoint, it's not like the DA saying they're watching the case. The judge is watching it, yes, but the judge is weighing this from a civil context, not studying everything everybody says. The case is over. There's verdicts. If people don't like it, they can appeal. Johnny Depp won a big money verdict, so the system needs to move on to other things. So sometimes, and I'm not saying she did perjure herself, but I am saying that people do perjure themselves, and the system doesn't take note of it that frequently. And part of that is just because the system is busy. Somebody needs to complain about it. Somebody needs to do something about it to activate that system. Sometimes they do, but most often they don't. But one of the problems is this willful element. So even if you're pretty sure they lied, you got to show that they weren't just wrong, that they knew they were not telling the truth when they said it. It can't be a mistake. It has to be willful because you want to put this person in prison for doing it. So it does happen. I saw a case in Virginia where a guy was charged with stealing a dog, and he testified that, nope, I never saw the dog. Then it turned out when the criminal charge was dismissed, they found him with the dog. And so then he was charged with perjury in that case. He must have really irritated the DA, the judge, everybody involved in this case for all this to happen. And apparently the way he was found with the dog was he kept walking it by his ex-girlfriend's house. It had been her dog, so she could see him with it and taunting her. And he had done other things allegedly in the case. So he was charged with perjury in that case and convicted. And one of the defenses was, well, you didn't see me with the dog until after the case was over. How do you know I was lying at the time that I said it? But the court said, nah, that dog had a collar on it. You knew what that dog was. You also knew it was the girlfriend's dog, so you can't tell us you just found it. If you had found it earlier, you could have returned it to her, but you had possession of the dog. So by circumstantial evidence, they did decide he was lying in that case. So it has happened in Virginia that somebody's charged with perjury and without direct proof of it, still by the facts and circumstances are convicted of it. But it's unlikely in this case. I mean, it's just probably not going to happen. But that's the story of perjury. You got to be able to prove this willful component of it. And that isn't something the DA takes up on a frequent basis. It just isn't. Otherwise, you'd be litigating every case, because you think about all these trials, people are constantly giving contradicting testimony one side to the other. So somebody probably is lying a lot of the times, but proving that and filling the court system with it is tough to do. So that's the story on perjury. That's the definition of it, how it works, and why you're probably not going to see it as a factor in this case. So now let's talk about lies in the First Amendment. There's two things you're sure to see if you get into a discussion of this in the context of anything to do with free speech or defamation or whatever, and that somebody's going to say, the First Amendment doesn't protect lies, bro. And the second one is, you can't yell fire in a crowded theater. Those are quick to type, easy to understand, and they completely do not encapsulate what the law actually is. So let's look at the first, which is, the First Amendment does not protect lies. Now, it's true that the Supreme Court has been pretty discouraging toward people who lie and who want constitutional protection. They haven't had good things to say about lies, that they harm discourse, they don't add anything, and those things are, of course, true. But that's not dispositive of the issue of whether the First Amendment protects someone's ability to do that. So let's look at that. In the case of United States versus Alvarez, there was a guy who habitually lied. He lied about everything. He particularly lied about military service, and I saw a picture of his uniform, and he had essentially every kind of award or whatever you could have on it. He even told people that he won the Congressional Medal of Honor, and he lied. And Congress had passed a statute that said you couldn't lie about rewards you received from the military, and there was an enhanced penalty if you claimed to have received the Congressional Medal of Honor and you had not. And he said those things, and they were lies, so he was prosecuted, and he appealed up to the Supreme Court and won, even though he was lying about it. The government made the argument that, hey, we can restrict false statements. That's not inside the scope of the First Amendment, and people who are lying about this are garbage dumps, and we need to protect the integrity of the military system. And those, especially those second parts, I don't disagree with. I'm disgusted by that as well. But here's where the Supreme Court started out, because this is a content-based restriction. This isn't saying you just can't talk about the Medal of Honor or your military service. This is saying you cannot lie about it. So they're looking at what you're saying and your viewpoint on it, and they're making a rule against it. So content-based restrictions on speech have been permitted only for a few historic categories: incitement, obscenity, defamation, speech integral to criminal conduct, fighting words, child pornography, fraud, true threats, and speech presenting grave and imminent threat that the government has the power to prevent. Absent from these few categories is a general exception for false statements. So the Supreme Court is starting off by saying, we have not said before that just because something is false, it is flat out outside of the First Amendment. You can do what you want, government. You can make any rule about it. Remember, the core of the First Amendment is to prevent the government from creating laws and rules that restrict people's speech, and at its highest level, political speech. The idea being you cannot let the government monopolize its power over people to stop the flow of thought and the freedom of people. So the court does recognize and distinguish that to say that, that's not to say you can't be held liable for the consequences of what you do in long-standing traditions, causes of action that invoke that, such as defamation. You lie about somebody, you cause their reputation damage, you'll have to pay for that damage you cause. That's not inherently protected under the First Amendment. For one thing, it's not the government holding you liable for the defamation. It's the other person, the person you injured, who's doing it. It's the government enabling the cause of action. But even in a case like defamation, you have limits by the First Amendment where they have said if it's a public figure, say like Johnny Depp was, then you have to show actual malice. So someone could lie about Depp, someone could lie about Heard, and they can't be held liable under defamation unless you can show that they were reckless or willful in the falsity of what they were saying. There are also other limits as well, obviously. Let's say I see you on the street and I say, I'm going to kill you unless you give me your wallet. And you call the police and the police come and say, hey, I got to arrest you. You're robbing this person. And I say, hey, all I did was exercise my freedom of speech. That's it. I'm just talking. I'm allowed to talk, aren't I? First Amendment, bro. You can't stop me. That's not true. That comes under the true threat exception. That also applies if you're on the internet and you say, I will come to your house and blow you up, like people seem to enjoy doing these days. That comes under true threat, and you can go to jail for that. Other examples are perjury, which we talked about, and also if you lie to a federal agent or if you impersonate one, you could be held criminally responsible for that false speech. Obviously, in the perjury context, the court says this goes right to the core of justice, that we got to be able to hold people responsible to tell the truth in court, or else we don't have a justice system. So that's an exception to the general rule that you can say what you want and whether it's true or not. But then the court gets down to business on this statute about the military honors, and it says many things, which is the government has to be held to, if it's going to try and prevent this, to the most narrowly tailored remedy it can. They find this statute very broad. But the court says flat out, they reject the notion that false speech should be in a general category that is presumptively unprotected. So when people tell you the First Amendment doesn't protect lies, bro, that's not true. It may have less protection in certain contexts than other speech, but really think about it. The government is not the decider all the time on what is true, which ideas are true or not. They have no business doing that. There's not yet a ministry of truth that gives you the official line, and if you cross it, you are held criminally responsible. Thank God we had a coalition of the kind of judges who confirmed this result of this kind of thinking at the court, even in a situation where it's a scumbag. Okay, a scumbag who's lying about how he served the country. But the statute was very broad, and if you put that one through the door and let it go, there'll be the next one, and you can't lie about this, or lie about this. Like the government never makes a mistake. Like anyone should ever trust the government to become the arbiter of truth. So that's the core of the First Amendment, and it doesn't allow them to be the deciders that we'll just stop you from speaking anytime we declare that you're lying under threat of criminal penalty. The Supreme Court says permitting the government to decree this speech to be a criminal offense, whether it's shouted from the rooftop or if it's just a barely audible whisper in your bedroom, would endorse government authority to compile a list of subjects about which false statements are punishable, and there's no limiting principle. Our constitutional tradition stands against the idea that we need Oceana's ministry of truth. Yeah, and never before has that been more important than now. Then they say, which I also deeply appreciate, if the court were to hold that the interest in truthful discourse alone is sufficient to sustain a ban on speech, it would give government a broad censorial power unprecedented in this court's cases or in our constitutional tradition. The mere potential for the exercise of that power casts a chill the First Amendment cannot permit if free speech, thought, and discourse are to remain a foundation of our freedom. So as a general rule, and as far as the government goes, the First Amendment does generally protect lies, or rather your ability to lie. The fact that you are lying is not sufficient for the government to create a statute against it and hold you to criminal penalty for that. It is in some limited context, and it is also a potential civil liability in others, but as a general rule, that is not a correct summation of the law, not even in defamation if it's a public figure case. So there's just many contexts where freedom of speech outweighs any kind of restriction the government can level on, and that whether something is true or not is not the determining factor whether the government has the power to prohibit it. That they do have the power to prohibit it, which kind of goes over this fire in the crowded theater scenario, is imminent lawless act. So if you're inciting an imminent lawless act, then the government can forbid that. It can punish you for that. So if I were to say, if this country keeps going the way it's going, someday we're going to have had enough about it, and we're going to throw this government off. I'm not inciting anybody to do anything right now. I'm just being frustrated and saying at some point it might be enough. If I say, let's go to the capital of X tonight and destroy it, kill everybody that's in it, the police could come get me for that. That could be incitement to a riot there, because I am giving a near future time, place, and action to commit lawless act and encouraging other people to do it. So there's your difference. Now that's a weighing function there, because how far out in the future does it have to be, etc. But even criticizing the government and saying you want to do damage to it, if it's not immediate incitement, is still lawful. The First Amendment is fairly broad, as it should be. It can't be reduced to doesn't protect lies. You can't yell fire in a theater. We owe that often repeated phrase to our friend Justice Oliver Wendell Holmes, who penned that while he was on the Supreme Court in a free speech case where the government was punishing somebody for being anti-war and not in any violent way. So not a good case, but he knew how to troll. What he actually said was, the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. But that kind of loses its effect, doesn't it? You got to think about lots of things when you say that. So people just say, you can't shout fire in a crowded theater. That's dumb. Can you shout fire if the theater just has a few people in it? Can you shout fire in the theater if there is a fire? What if it's very crowded and the manager of the theater comes up to the front and said, what would be the scariest thing that could happen right now? And you stand up and yell fire. So it's ridiculous to allege that this assertion holds any water if you actually think about it. The test that's in play now is that you have to be advocating a lawless act, and it's imminent, a true threat, and some of the other things that spoke about before. The fact is, in general terms, the First Amendment is a very broad protection for speech, subject to the exceptions that the court sets out. And these exceptions don't include just lies as a general matter. They don't include hate speech as a general matter. You can do that. They don't include misinformation as a general matter. Most things you're going to do in the public sphere are going to be protected by the First Amendment in terms of the government restricting you. There are very few exceptions to that. It doesn't mean that a platform has to allow you necessarily to publish all the thoughts you have, particularly if they don't like it or if it violates some kind of policy they have or whatever. That's a trickier situation and different than the First Amendment governing what the government can do to you. It's messy, it's unpleasant, sometimes it's unfair, but that's the cost of freedom. Give me that any day over a government who believes that it has the authority to control what thoughts come into your mind and what can come out of your mouth. I'd far rather have, and I do not like the government, but I'd far rather have the government we do have, which at its court level and sometimes even in the other branches of the government, respect and understand that there are limits on the government's authority to what it can do to its citizens just for what they think and what they say. However, there's an old joke about a guy who's in court really unhappy with how things are going and says to the judge, "Your Honor, can I get in trouble just for what I think?" And the court says, "No, of course not, sir." And then the guy says, "Well, then I think you're a son of a bitch." How do you think that turned out? There's a time and place for everything. Thanks.